Thank you to everyone for joining us today. My name is Sarah Hart, a partner in our Dentons Edmonton office, and I am co-lead of Dentons Professional Liability Subgroup and member of Dentons Litigation and Dispute Resolution Group. My practice focuses on professional liability claims as well as commercial litigation and shareholder disputes, and I represent individuals, insurers, and corporations before all Alberta courts and tribunals. Today, I am joined by my colleagues. Firstly, Rose Carter, KC, a partner who brings over 30 years of litigation experience in health law. Rose advises physicians, dentists, nurses, and scientific professionals on complex regulatory matters and disciplinary tribunals. Based in Edmonton and active nationally, she brings court-tested insight and a deeply strategic lens on issues like spousal hospital privileges and appeals. Secondly, Adam Blabel, an associate in the Litigation and Dispute Resolution Group in Edmonton. Adam handles high-stakes commercial disputes, including construction liability and professional negligence, in addition to health and regulatory law. His experience spans Alberta's courts and regulatory bodies, offering a multifaceted perspective on professional liability challenges. And last but not least, Justin Okerman. Justin is an Edmonton-based associate with a diverse background in health law, privacy, professional liability, product liability, and is bolstered by a very unique scientific and ICT law training. Justin offers a sharp, multidisciplinary approach to regulated professional issues, blending technical fluency with litigation understanding across health and regulatory domains. So without further ado, I'm going to call on my colleague, Rose Carter, first. So Rose, I'll have you come online. And Rose, I understand that you have had a really recent, a major precedent-setting decision in the Charkande versus Alberta Dental College decision before the Alberta Court of Appeal. So Rose, I was hoping that you could provide our audience with a case overview and why we went and how we got to the Court of Appeal. And Rose, if you could just pop on camera, that would be helpful.
We'll do that. Here I am. Thank you very much, Sarah, for that introduction. And I know that the audience is very interested to also hear from my colleagues, Adam and Justin, in this matter, who were a critical part of our team working through the process we had to go through and appearing in the Court of Appeal. So in short, the background of this case is that a dentist was charged in 2013, so that's 15 years ago, with sexual impropriety under the Health Professions Act. But I want to stress to the audience at the onset that the significance of the Court of Appeal is that it no longer just applies to the dental college or the professional medical colleges covered under the Health Professions Act of Alberta. And Justin and Adam will elaborate on this more, but it's broader than that. From a cost point of view, it impacts all regulatory bodies in the province. So we started out as required under regulatory law, appearing at a hearing before the dental college. The importance of that for the audience is to understand that the people who adjudicate the matter are not lawyers. In our case, there were two practicing dentists and two lay council members who heard the case. We lost at the hearing. And as required under the Health Professions Act, we couldn't go immediately to the Court of Appeal. We had to appeal to the council of the college. As often happens, the college in this case, pardon me, agreed with the hearing. And in law, there is a lot of deference given to hearing panels. So we also lost at that level. And then and only then were we able under law to appeal to the Court of Appeal of Alberta, which we did. The Court of Appeal's decision was rendered in January of this year. So I stress to the audience that this is a long process. fortunately, our client was able to continue practicing during that time. Finally, the significance of the Court of Appeal decision relates to costs, and my colleagues will deal with that extensively. However, I reiterate, Sarah, that this Court of Appeal decision applies to all regulatory bodies in Alberta. Furthermore, as you are aware, other provinces often will follow the decisions of other courts of appeal in other provinces. So, for example, Ontario may decide, or Manitoba, Saskatchewan, Court of Appeal may decide, if a proper case comes before them, to follow the Court of Appeal of Alberta. So this must, so other provinces have to be aware of this decision if they are governing in the regulatory sphere. The other significant matter that arose is the use by the hearing panel of the word other under the Health Professions Act. The Health Professions Act only governs patients, how patients are dealt with. So I'm going to ask Adam at this point if he would jump in and discuss that aspect of the case. Thank you.
Thanks very much, Rose. Adam, can we have you come online, please?
Yeah, absolutely. Thank you, Rose and Sarah, and thank you everyone for attending. As Rose said, before we dive into the sanctioning decision of the Court of Appeal, I'd like to discuss a finding made by the court, which could potentially have significant impacts on professional liability in Alberta and potentially in other provinces as well. So perhaps if we could go to the next slide, I can provide some quick background. And then just one more, please. Awesome, thank you. So for some background, the complainant in this matter was neither a patient nor employee of the member, although there was some issue regarding whether she had ever been his patient or was in fact a staff member. In any event, the hearing tribunal, its appeal body, the appeal panel of counsel, and the Court of Appeal found that she was not a patient at the time the alleged incidents took place. This raised a very interesting question as to whether the allegations, even if they were true, fell under the purview of the Health Professions Act. This was a topic the Court of Appeal had seemingly addressed in Yee versus Chartered Professional Accountants of Alberta in 2020. In this case, the court held that private conduct of a professional must engage either the broader public interest or the reputation of the profession to rise to the level of professional misconduct. The court in that case held that the closer the conduct comes to the activities of the profession, the more possible it is that personal misconduct will amount to professional misconduct. However, the court also warned that a professional may be a professional from, and I quote, the time they get up until the time they go to bed at night, but that does not make everything the professional does a matter of professional discipline. Next slide, please. Turning to the case of Charconde, in this case, the hearing tribunal found the member had exercised authority over the complainant, characterizing her as a, quote, other individual, whom the member had influence over. The Court of Appeal asserted that private conduct, that is, conduct not relating to the practice of the member's profession, can still constitute unprofessional conduct. The court acknowledged that the Health Professions Act does not contain the descriptors staff member or other individual, and in fact, the Health Professions Act did not contain any wording to this effect at the time of the alleged incidents in 2012 and 2013, or presently. Still, the court found the hearing tribunal had the jurisdiction to hear and rule on this matter. In fact, the Court of Appeal found the complainant would clearly qualify as a, quote, other individual, the key issue being whether the member exercised power or authority over her, which would bring her sufficiently close to the profession of dentistry. The court found no ground to overturn the hearing tribunal's decision that the complainant was an other individual and fell under the purview of the Health Professions Act. If we can go to the next slide, we can discuss the potential impacts of this decision. As Rose mentioned, the Health Professions Act, its purpose is to protect patients. But this decision expands the protection afforded by the Health Professions Act to individuals that the professional exudes power or authority over. This decision also broadens the power of regulators to discipline misconduct involving parties that are tied to a practice, providing them a mandate to protect the broader public. This is significant because it results in a loss of a key defense for professionals at the regulatory level. It's no longer sufficient or a sufficient defense to point out that a complainant is not a patient or a client or someone that's not explicitly contemplated for in the legislation. Misconduct can now be found in broader power imbalance relationships within this professional setting. In fact, the court's emphasis on, quote, power or authority makes power imbalance a threshold concept in these misconduct cases. Therefore, we can expect regulators to scrutinize these dynamics a little more closely in future proceedings to see if the conduct can be brought within their ambit so that they can make decisions about them. This is also a signal to all professionals that any relationship that is connected to their practice, even loosely, may attract regulatory scrutiny.
Adam, I have a quick question for you that I think might be relevant to our group is that you referenced the term other individual. How far does that term other individual go?
Sarah, that's a great question, and it's really unclear at this time where that line is. So in this case, in Sharkonde, the member had practiced for decades without incident. There were no patient complaints. So the question becomes, how does this impact or promote patient protection? Furthermore, it creates the risk that with greater breadth of power for these tribunals, it can create greater uncertainty. This can cause professionals to struggle with knowing where their professional obligations begin and end.
Is it a necessary change in your view?
I think it depends. There's two different conflicting views that one might take. Some might say that this is a catch-all provision that ensures that no wrongdoing can fall through the cracks, so to speak, so that it would be a positive change. But others may argue that for matters like this, there are other avenues for relief, such as criminal or civil courts. I myself fall towards the latter, as I believe our court system and our judges are experts in these types of cases.
And Adam, what would you tell our audience are the risks of empowering regulatory bodies to make these types of findings?
Yeah, absolutely. There's significant risks. Hearing tribunals, as Rose mentioned earlier as well, are usually comprised of individuals from the same profession and laypersons. These individuals on the panel are well equipped to determine the impact of the misconduct both within the profession and in the public sphere. This decision may result in complex legal analysis, however, being conducted by individuals without legal training and without any actual expertise on this topic. Really, the less connected the acts are to the profession, the less fit a tribunal or a panel would be in assessing liability. These decisions are also potentially career-ending for professionals. The Court of Appeal in this matter afforded significant deference to the decision of the appeal panel, which in turn had afforded significant deference to the hearing tribunal. There's no fresh opportunity to have the matter heard at the Court of Appeal level. It's really an appeal on the existing record.
Right. Now, Rose had mentioned earlier that this decision will have impact on non-health related professionals. So can you describe that a bit? How will it impact other non-health related professionals?
Yeah, absolutely. So this really opens the door for any regulator to assert jurisdiction or try to assert jurisdiction over conduct of their members involving non-direct contacts. So for example, engineers or accountants could face discipline for conduct involving people who aren't direct clients, but might be associated with their practice or their institution. So this is really a catch-all for conduct that is not specifically mentioned in legislation. And of course, we know this well. For example, the Legal Professions Act permits the sanctioning of members who act in a manner that's adverse to the public interest or harms the reputation of our profession. And I quote, whether or not that conduct relates to the member's practice as a barrister and solicitor, and whether or not it even occurs in Alberta. So it's explicitly stated in the Legal Professions Act, and that's something we may see going forward. We may see amendments to legislation for other professionals to incorporate or exclude this Sharkonde decision going forward.
Thank you so much, Adam. That's great. Adam, I'd like to now call on Justin quickly. And Rose, you mentioned the importance of the costs element of this decision. So Justin, if you could come online, I have a few questions for you, which I think will be pertinent to our audience about costs under the Health Professions Act. And in particular, I wondered if you could start with advising of what we mean by costs.
Absolutely. So if we could just perfect. Thank you very much. So costs, conventionally, when we talk about costs, it's a process in a legal proceeding where at the end of the day, we have colloquially the winner and the loser. And it's well accepted in conventional litigation that the loser is responsible for paying some of the winner's legal costs. And for professional liability cases, this would usually mean that the professional who's being sanctioned is responsible for reimbursing the college for some of the costs that the college incurred through the investigation and prosecution, the hearing tribunal, and ultimately coming to a decision on sanction. And that kind of forms part of the sanctioning decision. Where things under the Health Professions Act in particular get a little bit different is there is no mechanism, whether in the Health Professions Act or that the courts have established, where if a professional successfully defends themselves against an allegation of misconduct, that they can recover costs from the college. So costs in a professional regulatory sense really only ever flow one way, regardless of outcome. Now, that's not to say that a professional will be obliged to pay costs to a college if they successfully defend all of the allegations of professional misconduct. There's just no avenue for that professional to recover. And so some of the areas where a college can recover costs are set out in statutes under the Health Professions Act. And then there are also a few cases that have come out at the Court of Appeal level in Alberta that essentially help to frame and justify and explain those circumstances where costs are payable.
So with that in mind, how do hearing tribunals calculate these costs?
So if we could hop to the next slide, please. So in addition to those sections that I mentioned under the Health Professions Act at Section 104, for a long time, the tribunals predominantly focused on a case called KC and the College of Physical Therapists. For years, up until the early 2020s, this was kind of the starting point. There were other cases that helped, but this was the starting point for establishing how we determine costs. In this case, a professional was reprimanded and fined and had to pay costs totaling just under $90,000 in 1999 dollars. And the procedural steps of this case are complex. There was a lot of back and forth, but at the end of the day, the Court of Appeal reduced the costs award to $5,000 from $90,000, and also set out kind of a couple of threshold questions that tribunals should examine when they're trying to determine how much costs a professional should pay. And that included factors like the fact that costs are discretionary, but tribunals should exercise that discretion judicially, which basically means it should be a very objective, very law-driven analysis that shouldn't be tainted or colored by personal opinion of the conduct or of the professional. The court also said that full indemnity or 100% of costs is not the default. So we don't start at 100 and then work down from there. But there also isn't a mathematical proportion for costs. So we don't talk about for X kind of conduct, then you should pay 25% of the college's costs or 50% of the college's costs. The court also said the tribunal should examine how serious the charges are, the conduct of the parties, and overall the reasonableness of the costs. So a more serious misconduct should probably be assigned a higher costs award. If a party is difficult to deal with or obstructs an investigation or is difficult during the hearing process, that should probably increase the costs award. And at the end of the day, the tribunal should also take a step back and just objectively examine whether or not the amount of money that is being ordered to be paid in costs is reasonable on its face. And to that end, costs are not intended to be a penalty. Costs are meant to reimburse the college for a portion of the expenses they incur, but they're not meant to penalize. The other sanctions, and I'll speak to that a little bit later this morning, but the other sanctions are what is intended to be the punishment. Costs are not a punishment. And at the end of the day, as I mentioned, there is the reasonableness, but the court in KC included this phrase that costs shouldn't deal a crushing financial blow to a regulated member. So the cost award shouldn't be so much as to effectively bankrupt the individual and leave them completely unable to pay and homeless and penniless on the street. And so in the intervening period after KC was released, as I mentioned, there was a bit of a body of case law that was built up that considered these factors and applied them and gave some additional guidance for tribunals to assess what a reasonable costs award is. Now, unfortunately, even though it wasn't really consistent with the second factor that we have listed on the slides here, we started to see a bit of a pattern emerge where tribunals perhaps took a bit of an easier path and just started awarding percentages of 25 or 50% of incurred costs. And while full costs were very rarely awarded, we did start to see cost awards starting to creep up, and often starting to become very significant into the $100,000 and $150,000. And unfortunately for our client in this dispute, when we were preparing for our submissions to the Court of Appeal, we found that the College of Dentists was among the higher end of costs awards, at least in the province of Alberta.
So what happened, Justin, then in the early 2020s? What changed?
So next slide, please. So in 2021, after some recurring issues that we started to see, as I mentioned, with the usage of percentages and creeping costs, the Alberta Court of Appeal handed down this case, Alsati and the Alberta College of Pharmacy. Now, this case noted that the power to award costs is broad, and it is protected by the Health Professions Act, but the court observed and made some comments that the amount of money that was being awarded as costs was starting to become a problem. And so they tried to kind of reframe and refresh and remind professions that there are some procedures that should be followed when you're making cost awards. And so again, we see the court saying that costs are not intended to be a punishment, and went even a step further and said costs shouldn't even be automatic. Perhaps there are circumstances where a professional may be found guilty of unprofessional conduct, but that doesn't automatically guarantee that a college rather is entitled to receive a payment of costs. And they also, in doing so, made a comment that I think is very interesting, and it's that regulatory practices are a bit weird in the sense that a tribunal and the appeal panel are effectively an extension or an arm of a college. And so when a tribunal or an appeal panel makes an award of costs, it's essentially the college awarding costs to itself. And so tribunals and college and appeal panels should be cautious when they're making these cost awards, because it feels a little bit one-sided. You don't have the same impartiality of a judge, and that's not to impugn the independence of a hearing tribunal, but on the surface, there can be some concern that this is not the same as costs are treated in a courtroom. And so accordingly, the court really proposed a much more deliberate approach to costs, and said that the first step should be whether or not costs are even justified. And that's done before we engage in an analysis of the KC factors. Is costs even a justified action to take in this action? And if not, we go no further. If so, then we can evaluate those factors in KC. And so if we could hop to the next slide then. So we then, only a year later, have a very interesting case. In 2022, the Court of Appeal handed down the decision in Ginna. And for those individuals who are attending this morning who are associated with colleges, I'm sure you're intimately familiar with this case, because this really turned how we approach costs and professional liability on its head. Unlike Alsati, which is the previous case, Ginna was a complete departure from how we approach costs in professional liability. In this case, the dentist was handed down $50,000 in costs, which following publication of this court's decision was actually canceled by the dental college. And that's because the Court of Appeal essentially said the de facto, or the starting point is always no costs. It is part of the privilege of self-governance of colleges that they should bear the entire costs, 100% of the costs of investigation, a hearing tribunal, entirely, unless you can demonstrate that there is a compelling reason that a college should be allowed to award costs. And they really gave a fairly closed and specific list of these four reasons. One of them was engaging in serious unprofessional conduct, and they provided a list of a few different factors, but these are things like sexual assault on a patient or committing billing fraud. So really serious, really egregious misconduct. Where a professional is a serial offender. So this is where an individual has been hauled in front of a hearing tribunal several times previously and just doesn't seem to quite be getting the picture of how they should be conducting themselves. And then there's also some misconduct, whether that's within the scope of the investigation, so being difficult or obstructive during the investigation, or being difficult and obstructive during the actual hearing itself in front of the tribunal. And so interestingly, this case stood for a few years. And then during a preliminary appearance by us in judge chambers in the Court of Appeal, when we were seeking a stay pending our appeal being heard by the court raised the question as to whether or not the college had considered bringing an application for reconsideration of this case. And shortly after that appearance, we received notice and an application that the Alberta Dental College was filing an application for leave to reconsider JINA. And the court did grant that leave when the application was heard, and the court heard submissions for reconsideration of JINA concurrently with our appeal.
So Justin, with that in mind and looking at the Sharkonde case that you and our team argued, what did the court change for costs?
So if we could head to the next slide, please. So the court kind of changed its mind almost completely again. So it's very unusual that we see the Court of Appeal change or undertake significant changes to an established area of law in very short periods of time. We essentially flip-flopped twice. And so the written decision of our appeal has a very lengthy section discussing costs. And essentially, they made a comment, and I'll touch on this maybe in a slide or two, but the court held that they're being faced with an opportunity to approach professional disciplinary proceedings and how we look at costs in professional disciplinary proceedings in a fresh manner. And they said that they needed to do that for essentially two key reasons. Number one, the guiding principles have become unclear, as there's been a bit of a history of inconsistent jurisprudence. I suspect what they're referring to there is the turning of costs on its head with JINA, and then a little bit of inconsistencies, minor inconsistencies though, with the Al-Sadi case, and then of course the big change to JINA. But then the second was that the Court of Appeal has generally, and this is borne out through its decisions up to and including our case, that they show a great deal of deference to tribunals. And up until our case, they had shown a great deal of deference to tribunals on costs. But again, they reiterated what they had said in Al-Sadi and in KC, that cost awards are getting incredibly large. They're getting disconnected from the base fundamental principles that the case law had established. And on that basis, the court essentially stepped in and said, we need to establish that this is how things are going to happen. The case itself, as far as a Court of Appeal decision goes, it's very strong language from the court, I think, really emphasizing their frustration that colleges aren't following their instructions. And the court correctly identified cost awards have crept from the original KC decision in 1999 and just well exceeding any available fines. So we'll speak to other sanctions and fines, but the Health Professions Act caps fines at a maximum of $50,000. And we see in KC, I mean, that's almost $100,000, not accounting for inflation. That puts us closer to $140,000 in today's money. And the cost award in our cases was evidenced on that introductory slide, exceeded $400,000 in costs. So it was becoming a point where costs were becoming the primary sanction. It was a crushing financial blow. And the court flagged that this is going to become an issue for regulated professions who are considering whether or not to even bother defending, because if a professional is charged with 3 or 4 counts of professional misconduct and successfully defends 3 of them, the jurisprudence up to our case suggested that they may still be entitled to pay costs, and probably a not insignificant amount of costs. And so there's some serious concern that the court expresses that a doctor or a pharmacist who is facing professional misconduct charges isn't even going to bother to defend because they don't want to have to pay the costs bill at the end of it, even if they are broadly successful. And so the court in our case completely overturned JINA. They eliminated the presumption of no costs and kind of reverted back a little bit to an Al-Sadi approach, but with a modification on that test. So they said there is no presumption for the onus of costs, but in every case, the decision maker must very carefully consider, first off, whether costs are even warranted, and then if they are, what is the quantum. And so essentially that first step is to determine, we're going back to Al-Sadi, whether or not circumstances warrant costs.
So looking, Justin, at that two-part sort of decision, that the decision test the decision maker has to apply, how does a tribunal know whether costs are even warranted?
Sure. So next slide then, please. So again, emphasizing the Al-Sadi approach, the court was very clear that tribunals and appeal panels should not be using mathematical calculations. This is not plug in numbers, get number out. The number of allegations and the overall success of a professional are going to be relevant factors. So this is some subjective analysis that tribunals are being asked to undertake. At the time the costs are considered, at the end of a hearing, the hearing tribunal should already have imposed a sanction, and that sanction should be fit in and of itself before costs are even considered. So this is again suggesting that costs are not an additional punishment. They are intended to allocate some of the costs that a college may incur, but it is not an additional punishment. The court also emphasized that the seriousness of charges is not directly relevant to how much costs will be awarded. And they noted that the more serious that the misconduct allegation is, it may indirectly result in higher costs because a more serious allegation of misconduct may require additional witnesses, may require a more vehement defense on the part of the professional, and therefore extending the length or the complexity of the hearing, which may result in an increase in costs. But a 2-day hearing regarding an allegation of sexual assault against a patient will not necessarily have higher costs than a 2-day hearing on charting or a 2-day hearing on a billing practice. And so the allocations of costs is not going to be dependent on the charge in and of itself. There's also was a bit of an element of JINA that was carried over. The court held that if there's unreasonable or inefficient litigation, conduct of either party, so obstructing an investigation, being difficult, evasive, or unnecessarily prolonging the length of a hearing tribunal through misconduct, failing to introduce material evidence, overcharging or replicating steps that are unnecessary, refusing to admit to uncontested facts. There's a fairly long list of what the court deems difficult behavior, which will have ramifications on the costs award. And taking this all together, the court seems to be suggesting that where a hearing is for a relatively straightforward issue, where a hearing does not engage any of these difficult behaviors, and where there was a mixed success or relative success on the part of the professional, reading between the lines, it would be our opinion the court is really saying that there shouldn't be costs charged in those sorts of cases. And those sorts of cases make up a significant majority of professional liability misconduct hearings. The 2-week-long sexual assault of a patient type hearings are relatively uncommon in the broad scheme of things.
So Justin, with that in mind, how are costs quantified?
Next slide, please. So in short, costs have to be reasonable and costs have to be proportionate. And so when we look at that process, it's kind of, again, is a bit of a two-step test to a two-step test in a certain way. And so when we look at reasonable and proportionality, we have to look at, were expenses reasonably incurred? There's going to be a bit of a recurring theme with the word reasonable, but were the expenses reasonably incurred during the course of the hearing? Was the amount of money that the regulator has paid fair, and was it reasonable? Is it reasonable to transfer the burden of those expenses onto the professional? And is the cost award proportionate to the issue? And so, and then also taking into account the members' circumstances on that point. And so, again, we talk about how the costs are not going to be a percentage of some gross sum. And when we talk about assessing the whether or not something is reasonable or proportionate, that is going to require tribunals to know exactly how much the college spent. So it's impossible to determine whether or not expenses were reasonable if the professional and the tribunal don't know the cost outlay. And so in our case, at the moment, once we got to the Court of Appeal, the court flagged that the hearing tribunal and the appeal panel of counsel, while they broadly knew a dollar figure, the dollar figure wasn't necessarily current, or it was an estimate or an approximation. And the hearing tribunal and appeal panel had no idea what that money was spent on. They knew it was hundreds of thousands of dollars, but there was no information provided to explain that. And so in the lead up to our appeal, the Court of Appeal actually requested that both the tribunal and counsel for the college produce basically a bill of costs outlining and detailing what the expenditures were, so that the court could have some level of overview as to what was a reasonable cost. And there was some wording by the court over the course of the appeal that was really questioning whether those dollar figures were reasonable, we'll say. The court really struggled with a $400,000 costs award. And of course, again, seizing upon that crushing financial blow, that a cost award of that amount without even needing to provide financial evidence of the registered professional, that would be a crushing financial blow and unduly onerous to anyone, regardless of their financial circumstances. And so what we see is that hearing tribunals and appeal panels will likely need to be provided with some form of a bill of costs in order to conduct this reasonable analysis to determine whether or not that's appropriate. And of course, what we see is that there's no presumption, again, as I've mentioned, to entitled to recover legal fees. And where it is reasonable, those legal fees are going to be limited to the costs of one lawyer at a mid-level seniority at appropriate rates. And that is counsel to the college. And so this is the essentially, we almost see an element of the relative power and authority of a college, almost in a way being equated to that of a crown, that the college has all of these resources behind them versus a professional who's accused of misconduct may not. And so the courts are not wanting to place the colleges in a position where they can hire a team of the world's greatest lawyers and then dump that bill onto the regulated professional. So they are really capping the amount of outlay. And the court says that a college is free to retain as many lawyers as they wish at whatever levels that they wish, but that additional cost incurred above and beyond what we see in this restriction is going to be a cost that is going to have to be borne by the college and the college alone. And again, we are seeing what is almost starting to look like the court imposing a cap on what costs might look like. And again, while a tribunal is entitled to counsel under the Health Professions Act, the tribunal is entitled to obtain and retain independent counsel to assist them. The services which may be offloaded essentially to a registered professional are going to be limited. And they're going to be limited to the services that they are intended to provide, independent legal advice. But where we have a hearing tribunal is already being compensated to draft the decision, for example, the individual is not going to be, or the registered professional is not going to be responsible for double paying, essentially, both the lawyer and the hearing tribunal for those services. So if we could hop to the next slide then, please. Oh, I think we may have gotten slightly ahead of ourselves here. So I want to briefly touch on an element that both Rose and Adam addressed, and that is the issue of who these changes are going to apply to. And what we see is in previous decisions, and most notably GINA, other colleges outside of the Health Professions Act have distinguished those cases when it comes to assigning and assessing costs. And those cases have been distinguishable because GINA in particular is very heavily focused on speaking to the Health Professions Act. And what we see in this case is that the court does not seem to be limiting itself to the Health Professions Act. And while they reference the HPA and they provide examples or they use it to illustrate their point, they're very clear in their wording that, and I quote, principles that should be followed when allocating the costs of disciplinary proceedings This appeal offers an opportunity for this court to address the issue of costs in professional disciplinary proceedings in a fresh manner. Unlike previous cases under the HPA, like Jinnah, this case is written a lot more broadly. And we would take it to mean that this is a case that's going to apply not just to professions under the HPA, but to all regulated professions in Alberta. Now, the HPA when we were preparing for this appeal, we focused our efforts more so on the HPA than we did around other professions outside of the HPA. But what we're going to see is just as the same as the expansion of the scope to persons, not just patients, that Adam mentioned, but that these costs, new costs rules, are likely or very likely could be enshrined into other professions' disciplinary proceedings. So whether that's for lawyers, whether that's for engineers or accountants, these cost provisions are going to translate across those lines.
So Justin, I'd be a bit interested. We've talked a lot about costs, but I'd be interested with how the tribunals determine the sanctions and fines and other elements of the decision.
Yeah, so sanctions, and this is something we're going to focus a little bit more so on the HPA, because what was that issue under the HPA uses what we refer to as the Jaswal factors, which is a relatively old case that helps to provide a sanction or assess a sanction within the scope of HPA misconduct. It's actually a case from outside of Alberta, but it's been adopted and enshrined fairly well across the country. And when we talk about trying to assess a sanction, again, we see the court upholding Jaswal for a non-exhaustive list of considerations. There are, generally speaking, 13 factors that are listed in the case, but those 13 factors can be distilled into kind of 7 more general considerations. And that is the seriousness of the conduct on its face. So a allegation of sexual misconduct will be met with a harsher sanction than one for billing, for example. Fundamental purposes of sanctions. So in terms of trying to denounce or provide specific deterrence or general deterrence. So that is specific deterrence being trying to prevent that individual from doing that thing again. And general deterrence is trying to send a message to the broader community or the broader profession as to you shouldn't do that more generally. The personal characteristics of the professional. So history of misconduct. Is this the first incident? Are they a repeat offender? Have they shown remorse for their actions? Have they undertaken remedial actions to prevent this from happening again in the future? The impact on the complainant. So was this a vulnerable person? Was this a minor? Did this misconduct have a serious and lasting effect on the complainant? Were there additional mitigating factors that are taken? So this, again, we see some overlap between the different factors, but mitigating factors include things like taking remedial courses. Mitigating factors include, a positive history pre and post allegations. The impact of the sanction on the professional. So this is going to come down to an element of proportionality so that we aren't unduly punishing or harshly punishing an individual or taking away a practice permit for something that is easily remediated. And then, of course, as with any common law jurisdiction, we always look to parity with previously decided cases. Though the court in this case in particular did provide some commentary that it is difficult to really have strong parity with previously decided cases. Professional liability cases are extremely fact-specific and extremely contingent on the other circumstances. And so trying to find a case that matches exactly is going to be effectively impossible. So other cases and historically decided cases may provide some guidance or insight, but you're not necessarily going to find a case that exactly matches those characteristics. So the court did provide some commentary on these Jaswal factors, as most professional liability written decisions do. They correctly highlighted that a lot of these sanctions overlap in purpose. We talk about a lot of them come down to providing specific deterrence or general deterrence. But the court in this case really focused on sanctions as a mean to rehabilitate the professional. So yes, sanctions are intended to punish, but at the end of the day, the real underlying purpose should focus much more on rehabilitation of the professional, if indeed rehabilitation is possible. And while sanctions, the availability of sanctions that may be available depending on these Joswell factors may range in purpose, and some are almost exclusively a punishment, and others are intended to protect the public from future misconduct, denounce the professional, condemn the professional. When a tribunal is trying to decide the type of sanction, it is really going to depend on rehabilitation being the focus going forward.
So Justin, what kind of sanctions can tribunals impose?
There's a few different options that are available, and some are utilized a little bit more frequently than others. Sorry, next slide, please, if you don't mind. So generally speaking, the Health Professions Act permits a fine. So it is up to $10,000 per offense, and the maximum cap of a total of $50,000. Mandatory re-education requiring coursework, implementing practice management procedures, supervision by a custodian, suspensions are not infrequent. There are a few different options available, and usually those sanctions will be very dependent on the nature of the misconduct as well as those Joswell factors. But right at the most harsh possible sanction is cancellation. So prohibiting a professional from practicing in their profession theoretically indefinitely. Suspensions are usually for some period of time specified in the sanctioning decision. They can range from a couple of months to years. And then cancellation is, as I said, theoretically indefinitely, though in some circumstances there is an avenue for reapplication for reinstatement after a period of years. But when it comes to trying to pick one of those, this really came down to a significant issue in our appeal. We argued to the court that the sanction that they imposed was wildly disproportionate. Our client was found guilty of 5 counts of unprofessional conduct. They were fined the statutory maximum of $10,000 per offense for all 5 offenses, for the cumulative maximum of $50,000. And in addition to this, had their registration and practice permit canceled, and then, as we mentioned, had a very significant cost award exceeding $425,000 to $25,000. So in our decision, we made the argument that this was just excessive. And the court agreed with us quite strongly and was very clear, as I mentioned, that the purpose of sanctions should be a combination of the protection of the public, and in assessing what sanctions are appropriate, we should also be looking to how can we effectively ensure rehabilitation if the professional cannot be rehabilitated, then maybe that's a situation where we look at cancellation. Denunciation, retribution, and punishment, as per the Court of Appeal, are not primary objectives of sanctioning, except where they exist to serve to protect the public. So if a punishment also protects the public, so for example, requiring re-education on proper charting practices, that might be, attending a course and not being able to earn an income for the days that you're taking that course. That might be an indirect punishment to the professional, but that's a sanction that is very much in line with protecting the public by ensuring that the professional does not commit that misconduct again. So while those sanctions might have a punitive effect, we're enhancing protection of the public by generally deterring other professionals from doing the same thing, specifically deterring that professional from doing that thing again, and maintaining professional standards. But sanctions aren't really intended to be exclusively a punishment. And so when we we're looking as to what sanctions should be implemented, basing off some of that decision off the Joswell factors, but the court said that the tribunal should be acting proportionately. They should act with restraint, ensure that they are focusing on how the professional can be rehabilitated as opposed to punishment for the wrongdoing. And so in our case in specific, the court held that the hearing tribunal didn't address proportionality. The sanction that was imposed was disproportionate and didn't adequately weigh the need to protect the public with how serious the offense was. And in doing so, tribunals should be asking themselves whether there is a more lenient or lesser sanction, so something less severe than what they want to do that would have substantially the same impact. So, for example, instead of suspending the individual for 24 months, a shorter suspension, but with a rehabilitation program or some re-education to address the deficiencies would likely have substantially the same effect on an individual who misunderstood billing practices. So when we're looking at sanctions, what the court is really ensuring that tribunals are taking a very balanced approach to how these sanctions are awarded, and it shouldn't just be a punishment. They shouldn't be so severe or so harsh that they actually run counter to rehabilitation or unnecessarily prevent a professional from providing valuable services to the public, including to other patients. And so where the tribunal may feel the need to punish a professional for their misconduct, what we should be looking to do this is by way of fines. So a fine is intended to be exclusively a punishment. There is really no other reason to levy a fine. There is a small element of general deterrence that other professionals might not want to face a similar fine, but really the court noted that financially requiring an individual to pay an amount of money to a college that isn't related to costs is effectively exclusively a sanction. But the court also wanted the tribunals to be very cautious in how they talk about fines. When we deal with implementing a fine, when we have a tribunal that wants to implement a fine, there is a very specific set of questions that a tribunal should be examining. So, for example, tribunals should be able to provide a convincing analysis on why a fine is required. So the maximum fine is a maximum. You can't charge more than $10,000 for an individual offense, and you can't charge more than a cumulative $50,000. But that $10,000, $50,000 cap is not a starting point, and it is not a presumption. So in our case, the nature of the misconduct ranged very widely in severity, from a non-consensual kiss to an allegation of sexual misconduct. And so the tribunal awarded the blanket $10,000 maximum fine for every individual offense. And the court held that that's not reasonable. They expected the tribunal to be able to justify why every one of those justified the maximum fine. And even though our case involved allegations of fairly serious sexual misconduct, the court threw out all 5 charges of fines. So because of that, we are left questioning in what circumstances will a fine be justified? Because if an allegation of sexual misconduct is not a severe enough piece of misconduct to justify a fine, then where will fines be justified? Or was it just an issue that the hearing tribunal provided no convincing analysis on why the fine was justified in addition to the sanction? So if we could advance one more slide, please. And I want to just very briefly touch on the idea of suspensions versus cancellations of practice permits. So in addition to other possible sanctions, our client in this case the hearing tribunal did not impose additional sanctions in terms of re-education or coursework or other forms of rehabilitation. So the court didn't really provide additional commentary on those points. So the availability and how those interplay with a suspension, for example, will be a question that's left to the court for another day. But the court did provide some commentary on when to determine whether a suspension or a cancellation is justified. As we mentioned, our client had their practice permit canceled. And then on appeal to the Court of Appeal, this was overturned and a suspension was put in place instead. And the court highlighted that a cancellation is by far the most severe sanction that can be implemented to a professional. It effectively removes their ability to practice in their profession indefinitely. In certain circumstances, a professional may be allowed to reapply for membership, but depending on the misconduct, that may not be available at all. And so reality is in a lot of cases, if you're canceling the practice permit of a professional, that is taking away their ability to work in that area, potentially indefinitely. And so therefore the court describes cancellation as economic death, and that is a direct quote from the Court of Appeal. And that it is only available where the unprofessional conduct demonstrates that the professional is ungovernable, or where continued participation in the profession would create an unacceptable risk. So these are very, very high bars. And accordingly, the court acknowledged that cancellation will be exceedingly uncommon in the world of professional liability. And the court also held that where a tribunal may be considering cancellation on one of those two grounds, they should first engage in an analysis as to whether a meaningful suspension would accomplish the same objectives as a sanction. And in our case, the reason that the court decided that a suspension would meet the meaningful objectives of a sanction, the hearing tribunal found that there wasn't sufficient weight given to mitigating factors, and the imposing a cancellation was exceedingly harsh, given the existence of those factors, and so imposed a fine of a suspension, or rather a sanction of a suspension, as opposed to cancellation.
Perfect. Thank you very much for that, Justin, and for Adam. And obviously, Rose, I'm going to turn this back to you briefly, but obviously this Chiconde decision is extremely precedent setting and very important in the province. And I wondered if you might have any additional comments just to sum things up that you'd like to add.
Thank you very much, Sarah. Yes, I would. And I would like to speak more broadly than just this particular case, if I may.
Of course.
We live in very dangerous times where the pendulum has swung to the extreme in relation to allegations against professionals when it comes to any type of sexual impropriety. For example, the court, one of the justices in this case, was appalled and made his views very clearly known to the counsel for the college that the maximum fine, $10,000 for a kiss, was just outrageous. But without going down that rabbit hole, I want to speak more broadly, and that is that the premise for governing professionals and having regulatory bodies, such as for engineers, architects, all professionals, is because the professionals, let's use engineers, for example. The premise on having the ability for the engineering disciplinary process to govern an engineer is because other engineers who will be judging, who will be sitting in judgment on that engineer, for example, have professional knowledge that the average layperson doesn't. A bridge collapses. Why? What happened? How can this happen? That type of thing. So we have now moved into exceedingly dangerous territory, in my opinion, because we now have administrative bodies who are not conversant with criminal law. Sexual offenses fall under the Criminal Code of Canada. So to have administrative tribunals adjudicating on what could be seen as sexual offenses is, I find, very disturbing and concerning as a lawyer. Because what we are seeing during these hearings is that morality is coming into play and people are offended. And these individuals, not all of them, but some individuals must feel, as demonstrated in our case, that they are entitled to make decisions based on moral grounds only. This is offensive. It is also very important to note that there are other avenues open to people who feel that they have been inappropriately treated by a professional, whether it's a lawyer, dentist, whomever. And that is, they have civil courts. They can sue. They can go to the police, have criminal charges asked to be laid, etc. In Canada, we don't have moral courts. This is not Iran. We have civil courts, criminal courts, and administrative tribunals. And when the administrative tribunals start spilling over into disciplinary proceedings, it is very, very concerning for our democratic process and legal process. So I think under the Health Professions Act, for example, to have a law that's so draconian, if I may put it that way, is very concerning indeed. And I think that we as lawyers have to watch over this very, very carefully for the slippery slope. So thank you for giving me the opportunity to speak outside of our case specifically.
No problem. So that does summarize and end our presentation. So a special thank you to Rose, Adam, and Justin, and a congratulations on your win at the Court of Appeal. I would now like to open to our audience for any questions. If you could please post them in the Q&A chat. You'll see that button on the lower end of your screen. And we are happy to have our panelists address them for you. So I'll just wait a few minutes, and if you could please post your questions.
Sarah, while you're waiting for questions to come in, I think from a practical point of view, it might be helpful to the audience for me to pick up on something Justin said. And that is now what I expect will happen based on our Court of Appeal decision is that lawyers now will be demanding copies of solicitors' bills, outside counsel that have billed the college for their services, as well as costs internally so that they can see those. And so I anticipate going forward, there may need to be a two-step process involved. And that is if at the end of a hearing, the tribunal has not been given a list of the costs by the body that is prosecuting its member, then another hearing will have to be held on the case of costs. And I believe strongly, and I welcome Justin Adams' view on this, that now it is no longer appropriate for a tribunal to say we are applying, the member is going to be responsible for 50% of the costs, 15% of the costs, without any knowledge beforehand. Like before we went to the Court of Appeal on this case, I asked for the costs from the outside counsel for the college. And of course, they didn't have the costs available for the Court of Appeal. And so our client was left out there not knowing, having no idea what the costs were going to be. And when we filed our factum, the only costs that we could advise the court of at that point was the cost up to including the appeal before council. But we had no idea what the costs were going to be for the Court of Appeal. So that, I think, is noteworthy. And I'd welcome Adam and Justin to comment further if they wish.
Yeah, I do think that it would certainly at this point, given the strength of the wording in this case, it would be a error in law and certainly an appealable point if a percentage of costs was awarded and without the benefit of a bill of costs. I would argue that any percentage award is not going to be permissible going forward. It was technically inconsistent with Casey. It was technically inconsistent with Al-Sadi. But those were, read more as you shouldn't do this. And the wording in this case is as I read it and as I understand it, is you can't do this. It is no longer appropriate to just say 25% of a bill of costs, and certainly not without the benefit of that bill of costs. I think part of that reason is it becomes almost impossible unless it was a very straightforward hearing to review a bill of costs and say 25 or 50% with some of those qualifying factors that the court imposed of one lawyer at medium, a medium year of call, charging appropriate rates. I mean, just that in and of itself is going to require an element of adjustment. And if you have a bill of costs that involves even one additional lawyer or paraprofessionals, that falls outside of what the court here deems to be reasonable legal expenses. And same thing with the bill of costs for the hearing tribunal. There are the reading this case, I would take it to believe, and the instructions that we received from the Court of Appeal, or were copied on from the Court of Appeal, requesting that not only counsel for the college produce their bill of costs, but counsel for the appeal or hearing tribunal and appeal panel also produce their bill of costs. And there was some commentary on that by the court when we were in front of them, as well as in the written decision, that there's going to be a lot more work involved in determining what a reasonable cost amount is, and then not even what a reasonable amount of cost is, but what on that bill of costs is unreasonable, and then what a reasonable proportion of that would be. Because the court isn't saying one lawyer of an average call of at charging a reasonable rate, and that 100% of that is compensable. It's not. It's only a reasonable portion thereof. So it's going to be, I would argue, it's almost impossible to just give that a 25% or a 35% figure in the spirit of what the court is asking tribunals to do now.
Thank you, Justin and
Sarah.
Rose. Adam,
And Sarah-
anything else, or are you good?
Yeah, no, I mean, all I could really do is echo what Rose and Justin said. It seems that it really has to be a much more calculated analysis. And, as Justin and Rose probably remember, when the initial bill of costs was provided to the court actually rejected it and asked for an even more specific bill of costs to be provided. So really throwing out blanket figures, like Justin was saying, of percentages doesn't seem to be an appropriate model going forward.
Perfect. Well, you guys have been so thorough. There are no questions and answers today. So I wanted to thank everyone for joining us today and for engaging in this really important discussion. We really hope you found the insights valuable and applicable to your ongoing work. Thanks again for joining, everyone, and have a wonderful day. Goodbye.